Thank you for joining us today. My name is Ian Scott, and I am the managing partner at Scott Legal. And we're here today to talk about moving from a visa. So a visa that perhaps is a visa like a TN visa or an E2 visa or an O1 visa, but a non-immigrant visa, moving from that type of visa to a green card and what those options are. So a few things before we get started. Scott Legal is a full service immigration firm, so we do both non-immigrant visas and green cards, both family-based and employment-based. And we also do some humanitarian work as well. A few things with respect to this that you'll receive after this webinar. You will receive a copy of this presentation, the PowerPoint presentation. You will also receive a guide to a link where you can download guides with a lot more valuable information related to a lot of these different visa types. You'll also receive a link to set up a consultation if you have additional questions with respect to your particular situation. And the other thing is we do record these videos and then we do post them on our YouTube channel. So you will be able to view that and you will receive that recording as well. So if you do have any questions, please feel free to add them to the chat function or the Q&A function. We will get to all questions as well. So without further ado, let us move into the presentation. So the first thing I wanted to go over was just how the green card system works in the United States, because it is quite a bit different from other countries. Now, the way that the system works in the United States, or rather the way it works in other countries, is that they usually have a points-based system, and the points-based system might relate to getting points for speaking the language, for education, your work experience, your age, things like that. And then when you develop or you get a certain number of points, then you are eligible for permanent residency or a green card. Now, the way the system in the States works, though, is that there are just a list of green card categories, and if you're eligible for them, you can apply. So it's very, very different. None of the eligibility criteria relate to how long you're in the United States and things like that, but it might be that the eligibility criteria just really relate to meeting the requirements of that particular green card. And generally speaking, broadly speaking, rather, the green card categories are broken up into two areas. There are humanitarian areas as well, but for the purposes of this presentation, we're going to focus mainly on these two areas, which cover the majority of the green cards that are issued, and that's family-based and employment-based. And family-based is further broken up into immediate relative and preference categories. An immediate relative is a defined term, so it would be, for example, a U.S. citizen that is marrying someone, or a U.S. citizen child over 21 that is sponsoring a parent. The preference categories are other familial categories. So, for example, a U.S. citizen sibling sponsoring their sibling, that's under the preference categories. And those, they're just treated very differently. And one of the first things that we're going to talk about is that. And then we have the employment-based categories. And the employment-based categories are broken up into EB1 through EB5. So we have extraordinary ability. With EB1, we have EB2, which is broken up into kind of two components: national interest waiver and company that's sponsoring you for a green card. EB3 is company sponsoring you for a green card. EB4, our firm doesn't do EB4. It's a religious-based visa green card. And then EB5, which is an investment-based green card where someone is going to invest money in order to invest money and create jobs in order to get the visa benefit. So let's first talk about the family-based system and go from there. So as I said, the immediate relative is a defined term, and the reason that it's important is because the immediate relative category is always current. So this is something that applies to every single green card category, because the green card categories, the majority ones, the ones that immediate relative being the one exception, there are only a certain number of green cards that can be issued every year. Once those get used up, then people get put in a queue or a line, a wait. And that wait can be quite extensive. So for example, when we look at the preference-based category of U.S. citizen siblings sponsoring their sibling, the wait is around 14 or 15 years. So that means that the green card can't be issued during that period of time, and also means that you don't get any benefit of the application until the category becomes current. So immediate relative, the great thing about this particular category is it's always current. That doesn't mean you get the green card right away, but it means that you don't have to wait in line in order for the green card category to be current, such that you can file certain types of applications. Whereas the preference-based categories, right now, every single one of them is not current. So, for example, a U.S. Green card holder that wants to sponsor a spouse, for example. That's a preference-based category, and that's not current. So none of those categories right at this very minute are current. Often some of them are, but right now they're not. So that's what creates these different backlogs. Now, the second thing I wanted to talk about is the process. And the way that the process works in the United States is that you always are going to have a 2 or 3 step process for getting a green card. So if someone's in the United States, they can file it to the extent that the category is current, they can file an adjustment of status application. And with that, they can file the work authorization and travel authorization. But if they're not in the United States, they can file what's called consular processing. And then when we're looking at the family-based category, what we see here is we see people that, for example, someone is on an E2 and then their spouse is working for another company. So that particular categorization we're going to talk about in the employment-based context. But what we do sometimes see in the familial-based, it's family related, but family related to employment. But in the familial context, what we sometimes see is someone that's maybe in the US on an E2 and then they marry a US citizen, right? Or that's in the US on a TN or an E2 or an H1B, and then they have a parent that, or a child rather, that turns 21, a US citizen child that turns 21, and that child is able to sponsor them. So we do see a lot of people move to green cards using this particular category. And as I said, we're also going to talk about people moving to green cards using the familial-based categories through employment-based. But right now, this is just focused on when someone has a TN, E2, H1B, L1, or some type of visa like that, and they have some US citizen or some other family member that makes it eligible for them to get a green card. So that's what, and as I said, it's either a 2 or 3 step process. The time that we went through the kind of the first process, or I jump maybe to the second one. If someone's in the United States, they can do adjustment of status, and if they're not, consular processing. But the first part of the process is always going to be the objective part. So is the person a sibling, right? So birth certificates or something. Is the person a parent? So a U.S. citizen that's sponsoring their parent. Again, you're going to look at birth certificates and things like that. So that the first part's always going to be the objective piece. And again, this is whether it's employment-based or family-based, you're always going to have the objective piece first, just related to the category that you're applying under. And then if there is a third piece, like sometimes there are 3 things you have to meet. So for example, if a US citizen is sponsoring someone for a green card through marriage, then 2 years after the person gets the green card, they have to file yet another petition to remove the conditions, to prove that they're still married and they're still a happy couple and things like that. So that doesn't happen in all of the green card categories, but it does happen in some. So now we're going to move to the employment-based categories. And the first one we're going to talk about is EB1A, extraordinary ability. So what we have here is as I said, that the green card categories are really just a list of areas or list of particular categories, and then you just have to take a look at them, and if you're eligible, you can apply. So what this one's trying to get at is, has the person risen to the top of their profession? And so what they do is they list out 8 criteria here, and then you have to look at these and you have to see, are you able to at least meet 3 of them? So for example, if someone has a really high salary, they say, well, people that have high salaries, usually it's because they've risen to the top of their profession. So we compare it to what, like if someone's, qualifying under, I don't know, let's say an engineer, if they're qualifying, we look to see what engineers make. And if this person's making $1 million and engineers normally make 100,000, then we would be able to check that box. So a similar judging the work of others, when we look at things like American Idol, the people who are judges, they are people who are already accomplished singers, and that's the reason that they're judging, right? So that's another one that we use. And they're not, as I said, there are a number of here. We're not going to go through all of them, but this is definitely a category. And what we see, the category where people get a green card. And what we see here is often people who move to this category, they have a non-immigrant visa called an O1, and the O1 is gets as a non-immigrant. So it has it's very, very similar in terms of the things that or areas that the person has to meet. However, the green card is always going to be harder. So sometimes when you have similar areas, then you end up saying that when you people there's similar areas in the sense of non-immigrant and immigrant visa, the green card have very similar requirements. It's going to be for the green card, it's going to be maybe the O1 squared, right? So even though they look similar on paper, it's going to be more difficult. Similarly, when someone's on an L1, we don't have a slide on this, but I'll talk about it briefly. When someone's on an L1, then sometimes they move to EB1C, and EB1C is in the EB1 category, but it's ABC. And sometimes they do that because the criteria look the same, but doing the EB1C, where the company is moving a senior manager or executive to the United States, sometimes even though they look the same on paper, it's going to be kind of always more in terms of what's going to be required in order to get the actual green card. So the next one we're going to look at is EB2 and EB2 under national interest waiver. And we talked about this, that EB2 is broken up into national interest waiver and company sponsoring for your green card. But let's talk first about what EB2 requires under either of these two, the national interest waiver or company sponsoring you for a green card. There's threshold considerations, so you do have to have an advanced degree, which is a master's or higher, bachelor's degree plus 5 years experience, or exceptional ability. So exceptional ability, it's similar to extraordinary ability. There are a list of criteria, and you have to meet at least three of them. And in order to qualify, your area, your degree or your bachelor's or your experience or exceptional ability do have to relate to the field that you say that you are going to come to the United States to do. So when we look at national interest waiver, the very first thing that we do is we assess why is the person coming to the United States? Like, what is the endeavor that they're coming to do? And everything kind of falls around that. So that's something we spend a lot of time with clients, like first clarifying what is your endeavor, what is it that you're coming to the United States to do? And once you've done that, then you have to assess whether or not that is national importance, right? So it could be that you're saying that you're going to create a significant number of US jobs. It could be that in the economic impact related to that, it could be that you've invented something. It could be that you have developed policies or procedures that are innovative and going to revolutionize different things. So that's kind of the first step. The second step is or second requirement is that you have to show that you're well positioned to advance the endeavor. So the government is not kind of prepared to just take your word for it. They're going to want to see evidence that you are actually in a position to advance. So that might be that you have firm contracts or whatever already. It might be that you've already hired some employees. It might be that you have started an incubator, been accepted to an incubator. It could be that you have various patents and different things like that. So they really are going to want to see evidence that you are actually well positioned to advance the endeavor. And the final one is that the government should waive the labor certification. For this one, for entrepreneurs, it's quite straightforward because you can show that the lead case for this says that entrepreneurs it's not practical for them to get labor certification. But also, we're often pointing to things in prongs 1 and 2 related to related to that. So. The other thing kind of to take a look at here is this is a high bar. So this is not we get a lot of calls where people say, hey, I'm an engineer and there's a shortage of engineers, or I'm a pilot, or I'm a teacher, there's a shortage and I should get national interest waiver. But it is much more complicated than that. And then when you are looking at both the national interest waiver and EB1A, the application process is very similar. You're going to file an I-140 petition, which the I-140 is the objective piece. It's looking at, have you met the national interest waiver requirements? Have you met the EB1A requirements, like 3 of the 8 criteria? For both of these, you can actually self-petition. So that's something that you don't need an employer for. And both of these are the 2-step process. So they're both going to be at the situation where you're filing an I-140. And then if you're in the United States, I-485 and consular processing if you're not. Now, keep in mind, though, that this category, it has not been current for a while. It's not that delayed, except for countries like China and India, but it's about a year and a half delayed. So you're not going to be able to file the green card immediately. You are going to have to wait. So the next one we're going to talk about, and we're going to talk about these together, EB2 perm and EB3 perm. And what this relates to is just companies sponsoring you for a green card. And this is a way that a lot of people get green cards in the United States. And when just one, one backup thing with N national interest waiver, we do have a large number of people who move from E2 to national interest waiver. We do in a lot of other categories as well, sometimes O1, but E2 is a good one because they're making an entrepreneur argument and or that the company that they have is doing something that's in the national interest. So the this next one, company sponsoring you for a green card, and a lot of people get green cards this way. What we tend to see is people on H-1Bs because the person's already working for the company. Sometimes TN visas, again, because the person's already working for the company, because the very nature of this particular category makes it difficult for the government to, or the employer to want to hire someone if they don't already have familiarity with them and they haven't been working with them for some period of time, because it is quite an extensive process where they have to do quite a bit, and they're just not willing to do that if and they won't even get any benefit from the person working at the company for quite some time. So usually it is some relationship, and the process is quite an extensive one where you have to first deal with the Department of Labor. You have to file a prevailing wage determination to see how much the job should be paid. Then you have to, and you're also going to, and actually, and this is the first thing, is you're developing the job description, and you are developing a job description that looks at the minimum requirements. Then you are going through a recruitment process, and then you're also looking at various audit triggers, like if there's a foreign language requirement, if there are things that are outside those normally required for the occupation, and then finally, the Department of Labor filing, and it's not through USAS, and that's going to take probably 15 to 18 months to receive the approval. And then that's when you do the USCIS filing. And again, this is very similar in terms of the petitions that are filed. And I-140 is filed, and then based on whether or not the category is current, you're going to be looking at I-485 and consular processing and or consular processing. The next category is EB5, is an investor-based category. So this is one we see across the board, really. We see H-1Bs, we see TNs, we see CE2s, people that are doing EB5 and investing either 800,000 or 1,050,000 in a new commercial enterprise. So that's an enterprise that was started after 1990. So it could be like an E2 entity that someone started and they're investing in their own entity. That would be more of a direct investment. The other is regional center, which is much more passive. So there could be some organization that is building a large scale hotel and they're trying to raise $100 million, and there's a program where they're getting lots of investors, the green card. And the difference between 800,000 and the 1,050,000 is whether or not the business is located in a targeted employment area, which is an area where the unemployment rate is 1.5 times the national average, or it's a rural area. And then the investment, the one thing when you're making the investment, it does have to be money that comes from your personal funds, and rather than say retained earnings of the business. So the investment is one side. The other piece of the investment is that you do have to show where that money came from, and it's a very extensive analysis, and it plays out more like an audit. And the EB5 can only be equity, so it does have to be an equity investment rather than a loan or something like that. So job creation, you have to create 10 full-time jobs. It's not just any job. It's full-time, not part-time. There's a shared job thing that you can utilize, but we discourage it. It has to be it's not the same as part-time. It has to be very extensively documented. The people have to be green card holders or U.S. citizens. So we highly recommend that companies who want to do this enroll in E-Verify. Both the regional center and a direct investment will need a business plan showing that you need to create the jobs. And the money that is invested, there has to be a link to job creation. So that's something that makes it so that if you're like purchasing a company, so let's say you had an E2 and your E2 is based on you purchasing a gas station or something like that, or a bunch of gas stations, and you said, oh, I want to turn around in a couple of years after I spent 800,000 and apply for a EB5, that wouldn't work, because if the money just went to the seller, then it has nothing to do with job creation. And then the process here, it's a three-step process where you're going to do the I-526 first, or E if it's a regional center, and then you're going to be doing the I-45 and consular processing. And again, you have to look to see if the category is current. In most cases, especially if you're doing the 800,000, if not all cases, and right now the category is current. And then once you've had the green card for 2 years, you would have to file an IA-29 to remove the conditions. And the removal here is showing that you've actually created the US jobs. So other green card options that come up, diversity lottery, and I believe right now is the diversity lottery season. So if you are interested in that, you should go on the government website and apply for the diversity lottery. The instructions are quite clear. You don't really need to hire a lawyer just for the initial application. If you get selected, then I think it's a good idea to hire a lawyer. But you know, that's something you should do. And I believe it's until November, maybe the beginning of November. Humanitarian-based green cards. It could be asylum, it could be helping the police solve a crime, it could be victims against domestic abuse, so any of those, and then we always hope for immigration reform one day. Timing consideration. So sometimes these applications can take a long time. So EB-5, for example, can take years, 4 to 5 years. So you do have to make sure that you are kind of looking at your underlying status and making sure that you're going to be able to renew it. And really, if you have a single intent versus dual intent, you just have to plan carefully. And if you're working with good immigration counsel, they would definitely help you to do that. And we often have people that do parallel green card strategies. Sometimes they have, we had one person that did an NIW and he was doing EB-5, which was the stronger case, but then he did NIW and it ended up the NIW got approved. So he's on his way to a green card. And really planning is key here. And those are all the prepared remarks that I have. And so definitely if there are any questions, I'm looking at the chat. I don't see any in the chat in the Q&A and I don't see any questions. Let me just go to the Q&A. No, I don't see any questions here. So we will wrap it up there. Let me just go back one more to see. Okay, we will wrap it up there. Again, we will send you a copy of the presentation. We'll send you the PowerPoint link where you can set up a consultation, link where you can download guides. And yeah, if you have any questions about these different visa options, you know, we process all of these visas and green cards, and people, you know, definitely they are there are ways to get green cards in the United States. Thank you.